Hi, good evening. Welcome to today's webinar on navigating the crisis, jointly organized by the Law Society Pro Bono Services Office, as well as the National Trade Union Congress. My name is Liansheng. I'm your moderator for this evening's webinar. So I have some housekeeping matters before we get started. There are some relevant materials for this evening's talk, and it can be downloaded from the handouts pane in your screen. If you're using a mobile phone or a tablet, the icon should be on your top right-hand corner. If you're using a computer, you will see the icons in the panel on your right. Please download the useful materials. Some of them relate to the topics that we'll be covering today for today's webinar. Feel free to ask any questions during the webinar as well. You can type them into the questions pane and then click send. Your questions will be seen by the organizer and us only, and we will try our best to address them during the talk at the end of the talk. Please note that the discussion and the material provided to you is not intended to substitute any form of professional legal advice. You should consult a lawyer if you require very specific legal advice. So with that, we're going to start with our webinar this evening. It's been months since the beginning of the COVID-19 crisis. I know of many freelancers who have faced a loss of income, cancellation of work, as well as difficulties in finding new work. This pandemic has really affected many of us, and many of the freelancers that I know as well. So when COVID-19 first came about, there was a webinar which we did where we talked about the measures that were implemented in order to mitigate the impact of COVID-19. So with tonight's webinar, we are really looking at the question, what is next? So we hope that with this webinar, we can help to give you some information on contractual issues that freelancers face, that we as lawyers, as well as Patrick has come across, and as well as to share with you certain information as well as new initiatives that are being rolled out. You might have heard of the Realign framework or the Simplified Insolvency program that was debated in the Parliament recently. And with me today, two very distinguished guests. I have Mr. Patrick Tay as well as Mr. Ng Ju Kin. Patrick is the Assistant Secretary General of NTUC as well as the Director of NTUC's Legal Services and Strategy Division. Ju Kin is a lawyer. He has been active in many of Singapore's largest and most innovative transactions in recent years and is recognized by legal publications as one of the leading corporate and capital markets practitioner. Clients have described him as a very trusted advisor. He's known for his strategic advice and guidance. Ju Kin counts many of the major listed and unlisted companies as well as non-profit organizations as his clients. Hello, Patrick and Ju Kin. Thank you for joining us today.
Hello. Good evening. Thank you. It's a pleasure.
Okay, so let's go into it, right? The first thing that we're going to talk about, of course, is about contracts, right? And I think Ju Kin is the most appropriate person on this panel today to share with us some of the concepts about a contract as well as the elements relating to contractual issues.
Sure. Well, I think the first thing that I would like to say is this, that a lot of people think that a contract is made only when you have something on paper, only when you sign something. But the reality is that the law provides that even a yes answer to each other, as long as we are able to prove that there has been an agreement, that can actually form a contract. But of course, there are things that you need to put together in order to say that there's a contract. Just like, for example, if today I look at Patrick and I have a joke with him. I just say, Patrick, I'm going to give you $2 million, and I walk away. Now that is not going to do much for him. He's not going to get his $2 million simply because there are some elements of forming a contract that's not there. Firstly, he has not given me any consideration. So I walk away. I turn back. I say, it's just a joke. He can't hold me to it. However, if I seriously go to Liansheng and say that, hey, look, I have this very, very new product I have just discovered. I'm prepared to give it to you exclusively to market it. I will not share it with anybody. Are you interested? And if Liansheng look at it and said, I am ready to give you a check now. This is $1, just $1. And he hand it to me in my hand and he said, yes. If I try to say, no, I'm just kidding, I may not actually be able to do that anymore because the contract is formed. There's an agreement, there's a substance there, and there's an acceptance by Liansheng, an offer from me, of course. So, well, there are many other aspects which are related to legal analysis, whether a contract is formed or not. But what is very important is that be aware that having a written contract is always the best way to go forward with it. Notwithstanding, you can make somebody be bound by a contract, but there are many things that you need to put together when you go into a venture, when you go into a transaction, so that on both sides, we can be on a level playing field as much as we can. Of course, there's never such thing as completely equal because it all depends on your bargaining power. If I go to someone who is basically really desperate for my help, and I insist that the terms of my engagement is that I must be paid upfront, well, it's just a question of whether the person can walk away to find somebody else to do the same deal with him. But if not, even though there's unequal and level kind of playing field from a commercial perspective, we can still do a contract. Now, if you look at the screen itself, let me just walk through with you what are the things that if you are looking at a contract, what you should be looking out for. And in fact, these are things which you should think about even before you start going into an agreement with somebody. First line, it says, with whom are you contracting? Now, if you are going to go into a contract, you need to, from a commercial perspective, of course, you need to ask yourself, is this person somebody that is worthy of you going to a contract? Especially if your contract is going to bind you to exclusive dealing with him for 2 years, 3 years. So some of us freelancers, we have this script, for example, you're a script writer, and this script is actually able to be, kind of like used for different kind of plays, movies, etc. Someone comes to you and say, I'm going to take your script and work with you for $10,000, but no one else should have the script, whether it's for a movie, although I'm doing a play, but you can't sell it for movies, etc. And with that, is that something that you want to have as exclusive with him? Is he the right person? But more importantly, from a legal perspective, you need to ask whether he has the capacity to do so. So things like, for example, if a person is bankrupt, if he's a bankrupt, he's coming to you to say that I want to deal with you on a long-term basis. Now, he does not have legal capacity anymore as a bankrupt to actually sign a contract with you. In fact, he will have to go to the official assignee to get permission to do so. Of course, under certain circumstances, you will still want to deal with him. However, some of these checks need to be put in place. Or, for example, if it's a 12-year-old who come to you and say, hey, I really want to sell this product to my friends. And you think that, well, okay, I go into a contract, I give him all the goodies for him to sell to the friends. Later on, you try to enforce, and he say that, no, I'm not paying you. Now, can you really enforce against him? He's only a 12-year-old. Now, the problem is that you will have actually a problem because he's a minor. He does not have capacity to sign. So therefore, the first thing is, with whom are you contracting with? You need to ask yourself. Number two, what is the scope of your duties and what is the time frame that you have performed within that contract you have signed? Now, if somebody comes to you and asks you, saying that, okay, you are a fantastic musician. He wants your services as a guitarist in a pub, and you're going to be playing for him, okay, for the next 3 months. Now, if you sign a contract with him, thinking in your head that, oh, it's only for 3 months, because after 3 months, I'm going to move on to another show, because that show is going to pay me better, but it is not up until 3 months later. Lo and behold, you sign the contract without checking, and inside it says that he has automatic right, if he wants, to extend your contract, or rather to extend the term of your services by 3 months without you saying yes or no, as long as he's paying you at least the same price or a higher fee. Now, you may lose the ability to go and serve the second contract because that may pay you another 100% more. But so what? You have already sold your services for the next 3 months based on whatever terms the contract has written. So be very, very careful and scrupulous when you sign something. Read carefully. Don't just brush it aside. I know a lot of us go to the Singtel shop, we buy a handphone, it gives you 3 long pages of A4 size, tiny little words, nobody reads, we just sign. I guess if you're dealing with, service providers like Singtel, by and large, they will go by, fair dealing kind of policy. But when you're dealing with an individual, it's different. The law does not protect people who are careless, who are basically not careful at all. But it does protect people who make a mistake. But that is very, very narrow scope of protection. So don't expect the law to come and take care of you because you have not read the contract properly. Now, what about responsibility when something goes wrong? Be very, very clear as to who is going to bear responsibility. Sometimes you go into a joint venture with somebody to perform certain services for a third party. Now, as far as the third party is concerned, he signed with both of you, and he's going to look to both of you if it's not made clear in the contract as to who is going to be responsible for not turning up at that occasion. So, for example, both of you are supposed to give a performance, but one fell sick. Does it mean, therefore, that both will have to pay for the damages or loss? More likely than not, yes, because you're coming as a team. What if your performance is individual? You go in as if you are performing individually. Your performance is nothing to do with the other person, and you actually wanted to just be responsible for your own default. Then your contract needs to make it very clear. Otherwise, sign separate contracts. What about extent and the limits of liability? Now, sometimes you may think that, well, if I sign something and if I cause any damage or any loss to the other person, that's it. I got to basically, become a bankrupt because I can't pay. I don't have enough money to pay for all the damages. Now, you can protect yourself by putting some limitation of liability. So, for example, you may say that, okay, if I fail to turn up for the performance, the only thing you can sue me for is maybe 3 times the amount of fees that I would have obtained. I would have been paid. Okay. Well, to be fair to the other side, maybe if give yourself a timeline to say that if I cancel for any reason that is beyond my control, at least 3 months before the date of performance, then all you can sue me for is only 3 times what you have paid me. So if you have contracted to pay me $20,000 for that performance, then maximum that you can ever claim against me is $60,000. Sometimes you may also want to put limitation on the time that he can claim against you. And that is very useful because you want to know that if you sign a contract and after you've performed and perform the contract or do whatever is required under the contract, you want to know that by a certain time, he can no longer come and sue you for anything that he discovered later that he's not happy about. So you may be able to put in some, like for example, if you sell somebody a business that you have created, you have given the business on the basis that you represented that the business has certain things which you have put in place. Now, if you're quiet about the timeline, then he basically has 6 years limitation period to come after you for anything that he discovered later. But sometimes you want to have a good night's sleep. Okay, to be fair, you allow him 2 years to discover anything that might have been wrong with the business. After 2 years, if you have a limitation of liability in terms of time, then he can no longer come after you. So if he wants to find any problem, he needs to find it within that 2 years. So these are little things that you can actually consider depending on what the circumstances are. What about the reward? You'll certainly never leave it to a handshake to say that, okay, I trust you that you'll pay me whatever I deserve. Now, this kind of thing means that he's likely to pay you $1 to $100. And it just creates at least a platform for him to dispute what he ought to pay you. And that will end up with you getting delayed in your payment. You may have to go and spend money getting the lawyer to fight for you. So why not make it clear exactly what he's paying you, when he should pay you, and what circumstances you could actually get more. For example, if I say that I'm actually going to provide you with services for 1 day, but for any reason, he needed your services for 1.5 days, then there must be some clause inside your contract that says, yes, for the extra half day, I should be paid extra. And on what basis should I be paid extra? It may not necessarily be the same rate. In fact, you can even say, if for last minute request, I need to do that half day, I can commit to doing that, except that you got to pay me 2 times the fees for that half day. All these things are permissible. Make it clear. What about your personal assets that you actually do not really want to sell to him? You are just allowing him to use. Very often, we have people who have come out with a program, computer program that is very useful for use at exhibition, for example. Maybe, with the COVID-19, you have people checking in. You come up with a very, very good app that allows check-in by tens and 20s at one go. Now, you would want to be paid for him to use your app, but you are not going to give him the app forever. You need to make sure that in the contract, it is stated very clearly that whatever you have given him to use, even if he modifies it on the spot to use it to make it more suitable for his event, the intellectual property rights in it, the license that you give him to use is only for that event, and you take it back wholly, 100% of it after the event, so that he cannot say, well, I can use it for free the next time around. Okay, so these are examples of what are the things that you also need to take care of. What about if you go into a venture with somebody that is for long term, maybe for 2 years, for 3 years, you're going to do a venture together. Now, for people who are very savvy, they may find ways to dilute your interest. For example, you go in as a 50-50 partnership, 50% share. Now, because he's got a lot of friends and family members who are willing to come in and invest in the business after it becomes successful, you want to be able to say that you can't bring anyone in as a shareholder without my permission. That's what I call a veto right, a stop action kind of power in case your partner decides to do something that is actually detrimental to your personal interest as far as the business is concerned. What about restrictions? Definitely, you do not want yourself to be locking into a business and then your partner goes on with somebody else to build a similar business using all the knowledge that you have given him in this business to compete against you. Therefore, it's quite common to have non-compete clauses where you can say that, well, as long as we are in this business together, you cannot form another business or invest in another business that will compete against this business. These are all just protection to make sure that when you go into any kind of venture or transaction, all your rights are protected properly. Of course, confidentiality is important, especially for freelancers who are in the creative industry. You do not want even your creative ideas to be leaked out even before you could actually put it into a product, into something which you can earn money. Now, depending on which partner you work with and what kind of business ethics he has, that's the reason why from the very, very first line, I've said you need to know who you're contracting with. You need to, at least on paper, be able to protect the confidentiality of all the information that you share with him or any other vendors or customers that you deal with. And of course, when something happens, something really goes wrong, your partner or your customer or your supplier decided to pull a fast one on you and he or she defaults on the obligation that he or she is supposed to perform, then what do you do? What are the recourse? Well, we always say if you could go for mediation. If things are not that bad, mediate because it's the cheapest way to resolve a problem. Of course, if not, then move on to if it's a small claim, then small claims tribunal will be able to help. But there are a lot of limitations to what you can do through the small claims tribunal. Unfortunately, if it rolls into something big and it's really something which you need to fight for, then you have to either go to the courts to sue the person, or if let's say your contract has an arbitration clause, then you can only go and institute an arbitration proceeding to try to take action against the person. It's going to be long drawn. It's going to be expensive, but if the money is worth it, then you have to go for it. So that actually brings us to the question of what is the best forum to put in your contract to say that when there's a dispute, when there's a disagreement, who is supposed to adjudicate? Well, some people argue that arbitration is good. Now, one thing good about arbitration is that all the proceedings, most of the information most of the proceedings, all the documents are confidential. You're not supposed to be able to have access to the arbitration proceeding documents. For court proceedings, by and large, yes, but there are ways that people can actually get access to the documents. And also the judgment is likely to be public if it's a big case. So these are considerations that you also need to have before you decide whether your contract should have arbitration as a dispute resolution platform, or it should be courts that you resort to if there's any dispute. And of course, finally, can you walk away legitimately from a contract even though you signed it for 3 years? Well, that is where you need to consider whether you should put in some clauses to allow you to walk away under certain circumstances. We usually call them the termination clause. It could be a dissolution of your venture clause or whatever. For example, nobody ever imagined COVID to happen, but there are many contracts, not all, but there are sufficient number of contracts that we've seen in the market where they actually have a clause called the force majeure clause. It is a clause that says that if something that has happened and is beyond the control of the party who wants to walk away from the contract, he can actually walk away if the situation does not improve after maybe 60 days or 90 days. These are typical of a force majeure clause. So for example, if I sign a contract, again, use an example, let's say I sign a contract with Patrick, and we say that we will actually, each one of us will offer our let's say, for example, our hotels that we own, okay, for certain events for 3 months. And we say that you cannot deny us the use of each other's hotel for the events. But COVID comes and everything just cannot be done. And meanwhile, Patrick has another offer to say that we really need a hotel for the COVID situation. Now, can he walk away and say, I will now pass the hotel to the other party to use it and earn some money from it? Well, the question is that, do you have a clause inside that actually allows Patrick to say, look, it's a force majeure. This has happened for more than 90 days. Nothing has happened. You can't use the hotel for your event. I can't use your hotel for the event. Okay, we should call it quits and then enforce it and move on to the next venture. Okay, I guess I just touch on some of the major ones. There are many other aspects, but perhaps as we talk about some scenarios, we'll be able to share more.
Sure, Joo Kin, that's very useful, and you have covered quite a wide range of things, from the parties that's being contracted with, the limitation of liability. I think I hope that the freelancers out there don't feel too overwhelmed about it, and that's where I turn to Patrick and say, Patrick, so in terms of a contract, if the freelancers are looking at, for example, terms of a contract, are there standards that maybe NTUC has or other websites have that might set a tone, set the benchmark for how a contract should be? Do you have anything to share about that?
Yes, thanks Liansheng and Joo Kin for that very extensive and comprehensive sharing from a legal perspective. But I thought to share some practical tips for many of our freelance professionals out there. Because in where I'm from, NTUC in the labor movement, in fact, we have a freelance and self-employed unit, and of course, various platforms, social media as well as on the web, through our web pages, providing guidance to freelancers. In fact, I'm glad to share that in the last couple of years, there has been quite a bit of developments. Maybe many thanks to many of our freelancers out there engaging us, and of course, I think our legal primer, including this evening session, has in a way kind of like move the goalposts and of course push some new boundaries. So in fact, there are actually a series of things that have been announced in the past couple of years for the benefit and looking out in particular for freelancers, or should I say freelance professionals out there, because many of you are either sole proprietors working literally on your own. Many could be startups, micro SMEs, or even very small outfits, or even partnerships, for example. So you don't have the resources or the energies, or should I say the entire business development function, so to speak, like many large organizations or even quite a number of SMEs have. So actually there are a whole series of resources out there. I just want to allude to two, which were actually products of many of these consultation at the tripartite level, meaning with employers, Ministry of Manpower, as well as NTUC and the labor movement. So thanks to many of the consultations and engagements on the ground, we realized that there are a few burning issues which freelancers face. For example, late payment for their services, occasionally also non-payment of their services. We all know that many of our freelance professionals out there sometimes are at the should I say the lowest, or should I say the final person in the value chain. For example, like when you do a corporate video, for example, yeah, the actors and actresses probably get paid last because they'll pay the production company, and then production company pays the lighting crew, the people involved, and well, there's a whole chain. So therein lies this challenge which many freelancers face, and it's particularly important because many of them may be living hand to mouth, or even requiring they don't have certainty of income, they don't draw a salary like employees do. So every single payment means a lot to our freelancers. So what we have done is taking from this feedback, and of course the many challenges that they face, we have promulgated two very interesting or useful tripartite standards. Firstly, on key employment terms for freelancers, it's now has become a tripartite standard, meaning that is recognized by the tripartite partners. It's even put on the website, on the TAL website, in case you need to have a view of this document. Is at www.tal-tripartitealliance.sg, and under TAFEP, and you navigate your way, you should be able, or even if you just Google tripartite standards for freelancers, you should be able to land in the landing page where you'll provide some key employment, or should I say key terms in the contract for you to look out for. So things like name of parties, a lot of things that Jukin mentioned earlier. It's a very sort of template for you to follow, and it's a good guide, so that you don't have to get too lost, and you don't have to in fact dedicate a lot of resources and time to do your own research or even engage counsel. So for very straightforward contracts, they outline key employment, or should I say key engagement terms or contract terms for freelancers who offer their services to buyers of their services to look out for. So that's the tripartite advisory. The other tripartite advisory also, because in Singapore we have quite a number of media freelancers, creative and media freelancers, and we have been engaging many of them. I know many of them are tuning in as well. So there's actually another advisory specifically addressing media freelancers. So I think these are two major developments in the past couple of years. It's important. Why? Because this advisory serves sort of like an industry benchmark, and specifically addressing the needs of freelancers, addressing some of the challenges and problems they face. Firstly, for example, the contract terms is navigating some of these intricacies of the law. The second one, for buyers of their services to also look out for things to make sure that they are doing it not just fairly, responsibly, but also sensitively and progressively. So things like covering insurance and payment schedules, etc., etc. So I think these are very, very important, and these are two advisories which are useful. And well, as a silver lining as well, with these two advisories, actually, the government has, or should I say, the public sector has come forward to embrace these two sets of advisories, meaning they're going to put the money where the mouth is. So if you get engaged by the public sector agencies for your services as a freelancer, whether you're a media freelancer or any other freelancer, then the public sector agencies will comply with these two sets of tripartite standards. I think that's something good. We are still trying to outreach and evangelize so that more buyers of services, including in the private sector, will embrace these two standards. So actually, Tripartite Alliance as well as the TAFEP has actually recognized companies and businesses who actually embrace these advisories by giving them a sort of like a TA mark, called Tripartite Advisory Mark, that they have embraced this particular advisory, and when they procure their services, they don't just do it fairly, responsibly, but also progressively. So these are but some of the guides. When we had the first, we are in our 7th year of this LawWorks partnership and this series of primers. But actually, the very first, pocket series that we had as part of this LawWorks partnership was specifically looking at, it's entitled "Are You a Freelancer?" So actually, it's a nice handy guide which you can download from the Pro Bono Services Office webpage. And we will try to consolidate some of this useful information, and those of you who have registered and signed in, you should be able to download them at your convenience.
Yes, actually, like Patrick, you said, actually the freelancers are almost at the bottom rung, right? Because they have such an unequal bargaining position.
Yes.
So these standards actually do help to set up some norms so that it's easier for the freelancers to discuss certain terms with their potential clients or customers, right? Even if these customers are perhaps not TAFEP registered, or they do not expressly say they adopt this framework, but actually when you go into the website, you look at what the key employment terms you should be talking about. It's just a good guide for the freelancers to then go through the list and say, hey, yes, maybe I should talk about this with my potential customer and client, right? Even things like payment schedule. I think a lot of freelancers, when they come and see me and I say, oh, you haven't talked about payment schedule, have you talked about what happens if you are cancelled, you know, because freelancers, time is money to you, right? If you don't set up cancellation clauses, what happens if they cancel you 1 or 2 days before? Are you going to be remunerated? These are real things that I think there should be a conversation about with their clients and customers as well.
Exactly, Liansheng. Like, for example, like in this whole entire COVID-19 situation where there are a lot of uncertainties, minus the fact that later on we'll talk a bit about the COVID-19 Temporary Measures Act as well as the realigned framework. But we also, in part of the terms of contract, we also do mention expressly to have some form of dispute resolution provision in the contract, so that in the event there's some disagreement, yeah, I mean, we won't go into the intricacies of the law, but if there's some disagreement, at least there's a suitable platform for them to resolve or even renegotiate or mediate their disputes.
In fact, one of the things that I
actually some
I
of even for the contracts. Yes, Jukin, go ahead.
Sorry, I think there was a lag there. Okay, I think one of the things that I noticed is that, you know, recently there have been a lot of push for mediation, and even our Singapore Mediation Center, they have made it very friendly. In fact, you know, it will be good for everyone to actually familiarize themselves with how mediation works, and the cost is actually amazingly low for someone who is independent, who is professional, to come and help to mediate any disputes. I think that is one channel that it should not be overlooked. In fact, increasingly, some of the things that we encourage our clients to do is actually to put in a specific clause to make it compulsory for both parties to go for mediation first before they hit the button for arbitration or for court process.
In fact, just to chime in here, Jukin, just to add on to besides SMC services, in fact, slightly more than a year ago, last year in April, there's this one-stop center called the Tripartite Alliance for Disputes Management, set up again by TEL, the Tripartite Framework or the Alliance, where if freelancers do face issues that they want to mediate, they can actually, of course, again, mediation is a voluntary and depends on the consent of both parties. But if you want to a quick, accessible, and economical platform, the TADAM actually offers voluntary mediation if freelancers do get in a fix or get into a dispute. So this is another channel which I hope you can find out more from the website, TAFEP or TADAM website, and it's available. Information is all there. It's so navigate the web, like what Jukin mentioned, SMC, TADM, and of course many other dispute resolution routes that you can take.
I understand even in small claims tribunal, before the claims even go for a hearing, the parties are encouraged to talk between themselves before the mediator judge as well. So actually mediation is a very useful tool for a low cost dispute resolution mechanism. Yes. Okay. So now that we know the broad picture about the elements of a contract, the dispute resolution, where to find some of the resources, maybe we can go into some of the scenarios that we can then have Jukin and Patrick talk with us about. This is the first scenario. It relates to a freelancer facing difficulties in finding work. And it is quite common actually after circuit breaker, even during the period of circuit breaker, and then now that people are starting to go back to work, some freelancers still have problems finding work. And some of the questions that I've been asked include things like, what are the contract clauses that I must put into my contract? And I think that's something that Jukin could perhaps share with us a little bit more on.
Sure. Yeah. When we face our situation where the available work out in the market is actually less than so-called the suppliers or the vendors, I think the important thing is that we must make sure that when we sign and commit to a contract, especially when it requires us to be working exclusively for that project or for that piece of work, and it basically deprives us from being able to take on any other work, to make sure that a very, very well drafted termination clause is actually there. I think that, to me, that is the priority if I draft a contract in this kind of climate. Sometimes there's no point fighting over something that, it would just take too much resources to try to establish a position and try to hope that you will get compensation. Sometimes it's better that we have an easy way out by terminating the contract and move on, because life is tough in this environment, and every opportunity that we have to take on a new matter, a new case, a new project, we should grab it without being dragged down by something which is in dispute. So termination clause. The other one, of course, when we have a situation where the market, the availability of jobs, availability of projects in the market actually far and few in between. One of the things that we always face with is actually what you call a lowballing of fees by your competitors. Everybody is just trying to grab that little bit of work, and so sometimes it doesn't make sense for you to take on the work. So maybe you could think of creative ways, like, for example, okay, I can match my competitor who is ridiculous in the first place to actually offer such a fee, but give me a priority clause. In other words, I will do this job for you, and if I complete it successfully, I would like to have a clause inside to say that you have to give me the first right of refusal for your next project. Now, this can be whether it is a renovation project, or it could even be a performance that you have done. So you know that this person actually owns more than one pub. So when you perform in one pub, you might want to say that, okay, now when he has the same idea for another pub where my services can be used, I want at least a first right of refusal. Now, this is much easier than trying to convince him that in this COVID situation, pay me 10% more than my competitor, right? What else? You could also, you should also contemplate what are, looking at the scope. When the fee level is low, maybe you try to keep the scope narrow as well, so that you space out both your efforts as well as energy and time for other jobs, and there's no point occupying yourself with one project for 24/7 for a little bit more. So maybe you could find a way to cut a clause that allows you some way to either charge more for out of scope work, which we would normally encourage people to do, especially when they are providing services, or maybe to just scope it down to enough for you to take on another project at the same time. These are some examples I can think of.
Patrick, what about freelancers? What do you suggest that, when they are looking at negotiating with the customers or their clients, what do you think is good for them in terms of practice, for them to bring up or discuss or use as a template, for example, when they're negotiating with the other parties?
I think there are a few things. I think a few points to look out for freelancers. I mean, whatever trade. I mean, firstly, of course, you must know the value of your work. I think it's very important to value your work and your expertise and your skills. I know there are cases where some, offer their services at rock bottom prices just to jump on a bandwagon or to enter a contract, and it kind of compromises the whole profession as well as their professionalism as well. So do value your services. On the other hand, we understand that it's a difficult period of time, particularly challenging. I mean, not just for freelancers, it's every industry is hit in one way or another. Even employees in employment relationships are hit. So I think besides the fact that you value, also look at, at the end of the day, if you do and renegotiate, take on a contract, maybe perhaps a lower sum, or in an alternative way, or maybe the payment schedule is stretched, do see the long-term prospects of your customer or the buyer of your services, and also do a good assessment of the person you're transacting or entering a contract with, whether they are good, paymasters, so to speak, whether you're expecting them to be all right after the next 3 months, 6 months, or because some of the contracts that we see freelancers enter into are not just once-off contracts, or for a job that's probably 1 week or 1 day or a month, but some may extend through a period of time, and there's a lot of uncertainty. In fact, as we are talking, even in the labor market, for example, and the economic uncertainties are really causing a lot of cautiousness, both from buyers of services at the same time as well as employees. So there's a lot of anxiety, anxiousness. But I think important is to remember that our freelancers are not just here for the short term. If you are in doing something that we are very passionate, interested about, I think firstly, look at your value. Secondly, of course, look out for your service buyer to make sure that he or she is reliable, trustworthy, and whether how much you compromise will be for the longer good and a longer term relationship. And finally, of course, look out for the terms. I mean, what we're talking here is negotiating, and of course, there are some frameworks that are coming up to renegotiate, especially where, for example, a buyer of your services have already put you on a term contract for 2 years, but because of some extenuating circumstances, I mean, I wouldn't use the legal term force majeure, but in some extenuating circumstances, could be cash flow, could be a re-strategization of their focus of the company or the business, having to terminate the entire contract, or do an early termination, or even do a late payment, etc., etc. So I think you have to watch out for all this. There are several measures that are coming up. Yes, the measures help freelancers. At the same time, also are helping companies and businesses to tide through this difficult period. So a lot of it will be going down to negotiating and the relationship and building the trust and transparency between yourself as the freelance professional and the buyer of your services.
Actually, whenever freelancers come and see me, I always say, look, if you're going to be negotiating with the other party, it actually starts allowing you to detect whether there are any red flags, right? Because if you're discussing with them and they appear to be unreasonable, they don't want things to be in a written contract, then you also must think about whether it's worth entering into this contract with the service buyer as well. Actually, when you talk about the long-term contract, I wanted to check in with Joo Kin actually. With this pandemic situation, and if they are in a long-term contract, or if the freelancers are negotiating a new contract now in light of the circumstances, do you think it is wise to think about clauses catering to like what you said, force majeure, or for special circumstances, whether it allows them to postpone their services, etc. Do you think it's worth talking about this with the service buyers as well?
Yes, of course. In fact, those are great ideas, because at the end of the day, no one wants to be stuck in a contract that basically it can never work anymore because of circumstances. So I think a properly drafted equivalent of a force majeure is very important. In fact, termination clauses should go even to the extent of saying that for any reason, okay, whether it is because they fail to pay you your milestone payments, you want to be able to walk away. Okay, in fact, one of the challenges that I've seen in some of the people that I have been advising is that they have very nicely worded milestone payments, but at the end of the day, if, for example, they say that, oh, I get this very good contract that pays me $50,000 for a 5 weeks work, it's very, very high in terms of the rates that they are paying, except that they want me to be paid 10% only, and then everything else is balance 90% is at the end of the entire 5 weeks after I've finished performing all the obligations. And the worst thing is that in the course of doing it, I am actually required under the contract to not only suffer the 90% backloaded, but actually in the course of doing the work, I have to go to buy all the materials. I got to pay a lot of money out of my own pocket first. Maybe my margin is probably 20%. So imagine having to pay almost like 70% of the total amount that I'm going to collect out of my own pocket to go and prepare the materials, to buy the materials, to do up the product. Only at the end of it, he just paid me 10% because he walked away after 90%, walk away without paying me 90% for whatever reason. Now, even if I say I structured 10% along the way, now if I do not actually say that if you don't pay me 1 milestone or 2 milestones, I have the right to stop work. Question is that, do I really have the right to walk away from a contract, take on something else? Because what if he comes out late with the payment? Do I still have obligation to continue? If I take on another job, I then may have a problem of performing his contract. And actually all I could claim in that situation was actually late payment, interest payment. So with a properly drafted termination to say that, okay, if you don't pay me the second milestone within three days or 5 days, I give you notice and I can actually terminate the contract. That will not only secure your ability to move on to the next project, it will also put some pressure on this guy, because if he really needs your service, he cannot afford to delay on payment. Okay. So these are things which we should start thinking about in circumstances like this, where people tend to take advantage of a market that is soft, that have very little work for a lot of people who are competing to just get into the market, as Patrick has mentioned. Sometimes people lowball just to be part of the action because they have never done this project before. They want to get into the market. Now, these are people that you really need to sometimes think about whether it's worth competing against. And of course, back to your question as to, do we have some of these clauses in? I would say yes. In fact, if for any reason you really do not want to have a lawyer advising on the contract, the minimum you can do is to go to Google and look at different forms of contract and see how people actually structure their contract. It will give you an idea how to negotiate, how to have a better bargaining power.
Actually, I have an interesting comment from one of the audience members. They were asking, instead of, for example, termination rights that are being talked about in the contract, are there ways, for example, to have a robust contractual agreement where there are preventive measures being taken, say if there's a default from one party or the other? What are your thoughts about it?
As in trying to avoid the termination or trying to enforce the termination?
No, I think what the audience member was saying is probably, for example, if the person doesn't pay me, right? Can I also have a clause where I say I withhold my product and I don't give it to you?
Oh, yes, of course. It's a question of structuring that clause to say that, well, I have the, in fact, most of the time when we draft a clause that gives our client the right to terminate, we always use words like entitled to, but not obliged. In other words, I may not actually, even though I have the right to terminate, but in the circumstances, I may choose not to terminate, and I just want to go for damages. I want to go for suing you for late interest or whatever. Because, for example, if I have no other vendor, I have no other customer, I got to hang on to the contract. Or I have a customer who is waiting for me to finish the job, I can't afford to move to somebody else. I will just find ways to try to pressure my counterparty to perform the contract. So always reserve the right to decide whether or not to terminate and not make it automatic.
Okay. Patrick, what about your thoughts in terms of milestone payments? Do you have any suggestions about how freelancers should perhaps structure their milestone payments?
I think it varies. We have seen, depending on the nature of the service that's being provided, it depends. I think it could be a once-off kind of like a engagement for a particular day or event. Maybe you have a lot of MICE events. So I know many there are photographers who are freelancers. They provide photography services, for example. So if it's a once-off event and it's not a long-term kind of a term contract basis, I think they should give they should set reasonable periods in the contract when they are engaged with the service buyer to say, by when you need to make payment, or even for him to be present. They should also pay some form of either a deposit or a first tranche of payment. Again, the percentages and amounts and the timings are all at the freelancer's discretion, and of course depending on who had you rightly pointed out earlier, there's an unequal bargaining status between the buyer as well as the freelancer. So you do need to assess for yourself, and also again who the other party is or are contracting with, because they may have their own set of rules. It could be dealing with a global company where when they do procurement, they have a set timelines or set templates, or should I say, when they procure services, including dealing with the public sector. Yeah, there will be certain forms of standard policies of guidelines or payment schedules, which you need to be able to accept. So at the end of the day, it's your call.
Okay.
In fact, one of the things that might be helpful is actually to have multiple in your milestones before, especially when you are, just now I was talking about scenario where you have to actually spend money to get some of the materials in order to finish the product. You might actually want to cut the contract into two parts, where one part is the fee, which he can hold back and not pay you until you have performed. But when it comes to materials, make him pay a deposit, a further deposit every time you need to acquire or buy a bulk of the materials that would be required for the job.
Those are very good suggestions. Okay, let's move on to the next scenario, because I'm also wary of the time. This is actually quite a common scenario, and actually, I heard of people during the COVID period going into private hire work because there's no more demand for that now. This is a question that was posed to me, actually, a private hire driver where he has some rental agreement obligations. And then now, because of being the economy being affected, he has difficulties paying his monthly rent. So his question is, how does he minimize his losses? How does he reduce his exposure to the legal risks? Patrick, any thoughts?
Yeah, I think I've been seeing quite a few of these cases particularly during the circuit breaker period. In fact, I must say, particularly during the circuit breaker period, and many people working from home, and even after, even today, as we are talking, there are still quite a number of people are working from home. So therefore, actually, many of these freelance private hire drivers are facing a drop in income, a severe drop in income. So some, particularly during the circuit breaker period, had even come to me and asked for advice on how do they navigate this, because most of the time when they enter into some of these rental agreements, they just sign a dotted line and then just move on, and start doing their Grab driving, Gojek or Tada. But I really hope and urge each and every one of you out there who are in a way private hire drivers and who have rental agreements with some of these vehicle rental companies, please read the fine print. I can't emphasize more. Why? Because I've seen private rental or vehicle rental companies which sometimes put certain burdens or limitations on the agreements. Nothing happens fair and well, but when something happens, for example, you get into an accident claim or accident situation where there's large amounts of compensations involved, then the fine print is very, very important, because there may be some sort of like a loss adjusters come in, and then when the insurance claims against you, we don't want a situation where you become personally liable. I've actually seen 2 or 3 cases already in such situations for a variety of reasons. And so do for the first thing, if you are tuning in and watching this, and if you are a private hire driver, please read the fine print and see what to look out for, and see what is covered and what's not covered. I'm very worried because I've already seen a few cases. But otherwise, you all know that there was actually a COVID-19 Temporary Measures Act. However, unfortunately, that act doesn't cover private hire driver agreements when it was promulgated or introduced in Parliament earlier this year. So you don't really have recourse to that, which is why, in fact, for the first time in history, in fact, thanks to many of the freelancers coming together, banding together, and airing some of the challenges. In fact, as we are talking today, we have something like more than 200,000 freelancers in Singapore, actively in freelance work. And for the first time in history, in the budget, we had 5 rounds of budget. In the budget, we actually provide for the Self-Employed Income Relief Scheme, SERS for short. So that's one area. In fact, we have helped more than 100,000 freelancers already through SERS, and we're still doing a stock take because I think generally most of freelancers are aware. In fact, the awareness rate has gone up so much that we're also getting appeals from some, because there are some criteria, eligibility criteria set for this Self-Employed Income Relief Scheme. So, but generally, if we try to entertain also appeals in very hardship circumstances, and also at the community level. If at that point of time, or even at this point of time, you don't qualify for SERS but do face severe financial hardship, yeah, so do reach out to the various community help that is provided at the community level. So that's for cases of private hire drivers facing rental agreement challenges at this point of time.
Okay. The second question that I got also from the rental hire drivers was really about whether, when things are difficult, is one party entitled to just unilaterally change the terms in the agreement? Jukin, what are your thoughts?
Well, it will be surprising if, let's say, that the rental company would have inserted a clause like that, where they could just change the terms. For example, suddenly jack up the higher fee, or suddenly say that they could actually require you to drive 18 hours a day instead of the usual 7-8 hours a day minimum. I think, of course, there could be people, don't talk about rental hire, rental agreement. Let's say, are there any kind of contract, you could put something to say that one party has the right to actually amend it without consultation or discussion with the other party. Of course, such provision, I would say that if I'm the other party, I would say that, okay, I'll get a good lawyer to fight it, to say that this is really unfair contract term, and therefore it's not enforceable. And of course, there are whole slew of different cases on unfair contract terms that we can ride on to try to challenge that. But that is going to be terribly expensive, and it doesn't make sense for someone who is just hiring a car to provide the services to actually go down that route. I think by and large, look at the agreement to see whether there's such a clause. I don't think any fair playing employer or hiring or service companies like who is actually hiring private drivers would actually have this kind of clause. I think by and large, we need not worry about this. If it's silent, of course, it requires both parties to agree before you can change the terms.
Okay, that's good. So fundamentally, at the end of the day, I think it's important to read the fine print, like what Patrick said.
Yeah.
I think most of the times, sometimes we just take things for granted and we just sign it off. And then when really things don't go smoothly, that's when everyone goes back to the contractual document, because it's supposed to govern your relationship, and then realize certain things that we have overlooked when we were signing the agreement. For long-term rental agreements, actually that brings me nicely into the next slide, because I have heard about the new frameworks that were introduced in Parliament. Actually, at the I think earlier this month, Minister Edwin Tong talked about the realigned framework. I think it's hot off the press. So this is something maybe Patrick can help enlighten us a little bit more.
Yes, I wouldn't dare say enlighten, because I think the full details are not fully released yet. I was last checking it this afternoon. I don't see the full details yet, but basically, I mean, yes, as Liansheng mentioned, it's just been introduced in Parliament as part of the entire COVID-19 temporary measures that we are rolling out. So it's called a realign framework, essentially to help businesses to renegotiate their contracts. And when you ask me, so what is this realign framework? In essence, is to help small and micro enterprises who have been significantly impacted by the challenges of COVID-19, and who have a need to review their business models and contractual obligations. Essentially, will benefit from this realign framework. And it provides a quick and fair way for businesses to realign their contracts. That's why it's called a realign framework, with current economic conditions and of course business objectives, and at the same time also looking forward at the situation now. And in fact, Ministry of Law has kindly done up a short infographic, which I think we will provide as part of the deck of documents that you can access. So I won't go into the details, but do look out for it, because I think the full details and full works are not out yet. But essentially, the realign framework is to allow businesses, including micro businesses, to realign their contracts to tide over this very, very difficult period. We know that so we in essence we are trying to encourage parties to renegotiate their contracts instead of trying to put a hard stop, and then both sides, we want a win-win outcome at the end of the day. But again, take note, there are some criteria on who qualifies. The businesses will be subject to annual revenue cap, as well as businesses must have experienced a significant fall in revenue. And these are some of the gist of some of the things that have been coming out from the announcements earlier this month in Parliament. I was participating in the second reading debate as well, including later on we'll talk a bit about the insolvency framework. But again, there are some limit contracts that will be covered. I shared earlier about eligibility criteria. There are also certain contracts, for example, hire purchase, rental agreements, lease agreements, as well as certain specified contracts, and they must be entered into prior to 25th of March 2020 and governed by Singapore law. And at least one party must have a place of business in Singapore as well. So these are some of the things. I won't dive into the details, but it's there for the reading. It's at the Ministry of Law website, and it's very instructive. And we will also provide the links as well as the infographic, which will give you a quick summary or the key points which I've just shared.
Yeah, actually the infographic is in the handout pane, where the audience members, they can just download. Like I said, if you're using a laptop, it's somewhere in the right, you look at the word handout, you'll be able to download the infographic. Patrick has mentioned the Ministry of Law website also gives quite a bit of information about this realigned framework as well. Which brings me to actually the expansion of service, the expansion of assistance that has been rendered to freelancers. Patrick, do you want to share something about the Enhanced Care Fund as well? I think that's something that's in
we have rolled out, well, this is for NTUC union members. In case you're wondering, the labor movement is actually trying to support and of course fill the gaps where there are gaps. In fact, last night I met one union member who came to one of our advisory sessions and asking, what if I fall through the cracks? I don't qualify for this, I don't qualify for that, and because of the nature of the business, I'm the boss and I'm the director at the same time, so there's a whole series of so there are actually situations where some of our workers, including freelance professionals, who may have fallen through the cracks. So we have actually come up with the first tranche of the COVID-19 support grant, or should I say the NTUC Care Fund, in response to COVID-19. The first tranche was already out. The second tranche, just to do a very contemporaneous sharing, will be starting off next Monday, 30th November. So we have provided some infographics on, I mean, it's not a large sum of money, but at least a bit of support to help pay some bills, and of course tied to over and above, and I repeat again, it's over and above every other national governmental support, as well as tripartite support that's been dished out. So this is just one small way. I mean, we've been raising funds in the past many years, and we're now really putting it to good use to support all NTUC union members, including our freelance professionals.
Yeah, there has been actually quite a lot of support. In fact, in the first freelancing webinar that I did with Patrick, we were also talking about the training grant when it was rolled out. SARS, for example, like Patrick, you have just mentioned, where it has helped quite a number of freelancers, as well as freelancers who had to appeal and then finally got the grant as well. Even within the community, I've heard of, for example, Goethe Institute giving grants to design makers to apply for the grant and create work in times like this. There are actually a lot. NAC has a digital presentation grant. Even within the community clusters, they also have certain grants at their CCs where they're helping the people who are less fortunate as well. So there are quite a lot of assistance around as well.
Liansheng, thanks for the reminder. Because yes, we did the first series quite a while back, and in fact, the self-employed, or should I say freelance and self-employed training scheme is still ongoing. It's still there, and there's actually for those who want to embark on some training during this downtime, or even if it's not downtime, to pick up some new skills, particularly now with many freelancers having to pivot, having to transform their business, and having to look for new opportunities. There's actually a series of programs for small businesses, for freelance professionals to build up their capabilities during this slightly slower, or should I say, a downtime. So actually, please make full use of those programs. In fact, just to add on, if you are a union member, I think there's also over and above that additional support as well in terms of course fees, and in terms of even training allowance to help you in a way to tide over those period of time where you are doing training. So the training comes in various forms: hybrid, online, face-to-face, in a variety of formats. So it's still on. So do check out one of our training social enterprises. NTUC Learning Hub is doing quite a bit in this space, and of course the various the NTUC webpage would be able to link you to many of these opportunities.
Great. Of course, part of the expansion about the COVID-19 Temporary Measures Act as well, in addition to the realigned framework, as well as the various grants that we have talked about, is also another program that was talked about during Parliament as well by Minister Edwin Tong. This program called the Simplified Insolvency Program. Of course, it deals a lot more with, for example, when you don't have the money and you have to end up taking certain measures. And I think Jukin can help us shed some light on this as well. Jukin, I think you're on mute.
I'm so sorry. I didn't realize I'm okay. I was just saying that before this simplified insolvency program was actually introduced, I think one of the biggest challenge that some of the small creditors have is that it takes a lot of effort, a lot of time, a lot of complicated maneuvering, if you can put it that way, to get something through in order to get a company that owes all these creditors money to get through all the process before you can dissolve the company, distribute whatever is left in the company. Because when the company is insolvent, unless there's actually really good business prospects that could be rescued with people coming in to put in more money, but there are situations where it is better to wind up the company in a fast and quick way. And I think this simplified program is really to help both sides to come and resolve something that will enable the company to either move on with business, do whatever distribution they need to, or for people who are claiming to make it much easier for them to just resolve the distribution problem. I'm not sure whether, Patrick, you have some other insights into this and maybe the rationale for doing the program.
Yeah, I think essentially this is from one perspective, of course, if you are transacting with some of these companies that are going insolvent, a bit of a challenge, but essentially also to provide a way out in that sense. I don't have the full details. I think they are still also I was just also checking the MinLaw website this afternoon and trying to extricate the full details. I think the MinLaw has explicitly said that they are going to provide more details on the actual procedures, because I think there'll be some changes to relevant rules and regulations as well in this aspect. But otherwise, essentially, is to provide a very should I say, a more simplified way, to end the entire, or to carry out the insolvency process. As you know, many of you who are aware, I won't go into the intricacies of insolvency law, but there are various ways to become insolvent in that sense of the word. So this actually provides a simpler format, cutting down a bit of more of the red tape, should I say, and to make it easier for businesses and companies. And of course, it's a way out for them to, in a way, to breathe and to be a bit above the water.
I guess at the end of the day, it's really just to provide various avenues for people to find a way out to deal with the circumstances, just as there are assistance for people. If really the businesses are unable to carry on, or if the individual is unable to carry on, there will be certain measures that can be taken so as to cut off your liability as well for these people. So that's the insolvency program. Let's look at the last scenario.
Maybe just one thing to add. If anything, this program will definitely cut down on the cost of getting things done or getting things sorted out. Currently all the cases that we see out there, is either that you have enough people with deep pockets to go through the entire process of whether it's a scheme or whether it's a liquidation or whatever. Otherwise, very often the smaller companies, they're just left hanging there, and it does not actually benefit both the company, the owners, as well as the creditors to just have this kind of situation where you just cannot move beyond seeing everything collapse.
Sure. So let's move on to the last scenario we have for tonight. This is also a question that was posed to me, where again it is a contract for services. There is a long-term contract. There are certain milestones during the term of the contract, but there has been some, which is quite common for freelancers in the climate now. The question, of course, is what happens to the freelancer? Will he still get paid, given that the service buyer has now been badly affected? And then what happens if this service buyer actually is insolvent? What does that mean to the freelancer? Joaquin, you want to start us off first?
Yeah, I think the first thing we have to establish is that what is the status of the service buyer? Because if, let's say, just because a company is insolvent does not mean that he will not continue to pay. He may choose to pay certain people with whatever resources he has, because a company can be insolvent but yet still earning money, still earning revenue. But it's just that he doesn't have enough to actually pay for all the debts that are now, building up by the day. But if, let's say, for example, the service buyer has declared himself or itself insolvent, and therefore it has called for maybe a debt moratorium. In other words, he has gone to court to say that I can't service all my debts, and therefore I ask for the court to grant me a period to sort out all my circumstances. In the meantime, no one should be allowed to sue me or to take any legal action against me or to even do anything to seize my property. Then during that period, unfortunately, the person who is not being paid, even though he may have a very well-written contract, will not be able to get any payment. Because anything that comes out of that might be seen as, if it's only to pay him and not the rest of the creditors, may be seen as a preferential payment, which is not allowed under the law. So, and of course, if the service buyer is still operating as per normal, the person can consider suing the company, but it might be good money down the drain, because at the end of the day, if he's got no money to pay, he's got no money to pay.
Then Patrick, any practical solutions? If I can't sue, if the person is bankrupt or if the company is wound up, what are the remedies for the freelancers? I think Patrick, you're also on mute.
Oops, sorry. Yeah. So as I was just alluding to, as all of us know, when insolvency proceedings kick in, there's something what we call the moratorium. So without leave of court, you aren't able to enforce certain things. I mean, in fact, recently I was just involved in particular case, a company being going to insolvency, and in that case, the union has to apply for leave of court. Of course, there will be cost involved, but I think so. What we have seen in the Simplified Insolvency program, I think the more details, if you want, for those who are interested to know more, again, it's the MinLaw website that's provide quite a good rudimentary or basic brief on what it involves. But you also envisage a situation where either a company which cannot be rehabilitated. I think in most instances, if you look at insolvency, we are trying to see how best to help the company or the business rehabilitate, right? Or try to meet some of the requirements through whatever that's available. And but if really it's a situation of winding up, then unfortunately, well, we had to go through the whole rigmarole of filing proof of debt, etc. But otherwise, I think important is to also realize that as one of the key aspects of that Simplified Insolvency program, since we are on this topic and on this point, is that we will try to achieve the best, or should I say, a win-win-win among the parties, the creditors, and of course the business. Hopefully, can continue as a going concern. So I think that's key. But I just wanted to allude to this Simplified Insolvency program simply because it's new, and also because it provides, as Jukin mentioned, a bit more cost-effective way, or should I say, I wouldn't say it's free, but it's a bit more cost-effective, and some of the processes has been minimized, or should I say, I wouldn't say cut short, but less onerous on particularly small micro enterprises and small businesses. So well, that's all I can say. Is in fact look out, and if need to, there's a realigned framework to before, if we really go into the whole insolvency thing, try to sit down and renegotiate where possible with that service buyer where possible.
Yeah,
in fact, one of the things that I think that Patrick actually did mention is the proof of debt. Just because a company has gone down doesn't mean that you should not make sure that your own proof of debt is actually submitted and on time, so that the liquidator or the administrator can take into account your debt. Now, you are not likely to get 100% of everything that you are owed, but even if it's 10%, 20%, sometimes it could be as good as 30%. If you don't put in your proof of debt, it is gone forever once the company is wound up. So it is important to track what is happening. Unfortunately, it's tedious, especially when all of us are busy trying to make a living. But it is something which hopefully maybe there will be some kind of cooperation or cooperative or framework where this can be tracked. I mean, given the advance in technology, maybe some association can come together for their members to track some of these payments.
So actually, just looking for your information, in fact, NTUC, the labor movement, we actually do support. In fact, my legal team and myself have actually assisted some companies, not this period of time, but previously, to file proof of debt. So if you are if you are a union member in a unionized environment, we have the union to pick the tab in this aspect.
Oh, that's great. Yeah, that's great.
That's great. No, then it leads me nicely to the next slide, which I want to talk about, which is really the resources that are available. We have covered quite a large range. We have talked about, of course, the contractual issues, as well as talking about the COVID-19 Temporary Measures Act, and then the expansion of it into the realigned framework where it allows parties to renegotiate long-term commitments, to finally, if really renegotiation cannot happen, then are we really looking at insolvency processes? So this is what we have really covered. And thank you, Patrick, for talking about the NTUC union helping to file proofs of that as well. And I think NTUC has also done quite a lot of work because as I was talking to Patrick previously before the seminar, I found out about the self-employed and freelancers unit as well.
Yes, that's right.
Yes.
Yeah, if I just share a bit, we started the freelance and self-employed unit simply because we started engaging some of the freelancers in the media community, as well as some of the photographers along the way. The past 6 to 7 years, we have a lot of focus groups. So we decided a couple of years back to set up this unit for freelance and self-employed. And I must, congratulate the team, for building a few big communities. For example, like the Private Hire Association, which is part of this freelance and self-employed community. We also have the National Instructors and Coaches Association, which is also part of this community. And because of them banding together and forming these various freelance associations, I think we have managed to move the needle in some of the policies, the laws, as well as even in budget this year. I think they have heard it loud and clear from the labor movement. I think because of this ability to not just aggregate, amplify, but also bring people together and to share to voice out the concerns and the needs. So first time in history, we have a budget where really looking at help, specific help, targeted help, looking at purely at self-employed and freelance community. So I think it's important. So I think one key message I hope everyone take away with this is, well, we have a freelance and self-employed unit in the labor movement. We can't be everywhere because there's only a small team of them, but we are trying hard to form various communities and banding various craft professions or areas or trades together so that we can overcome some of these challenges. A good example would be, for example, the National Instructors and Coaches Association, which I alluded to earlier. I think they were badly affected during this COVID-19 period because many of them are giving, instruction, either they are coaches to sports, could be bands, and of course even adventure training, for example, to many of the schools out there, because with home-based learning and cutting back on all these overseas trips and all these training and co-curricular activities, a lot of their incomes were affected. So actually the team worked together, NICA for short, worked very closely with the Ministry of Education, and to airing some of these concerns, Ministry of Education actually, I wouldn't say totally bend their fingers, but continued the payments to them. In some instances, even pay them in advance for 2020, 2021, to help them tide over the period, and still put them on a retainer of sorts so that they don't lose their income totally. And this is over and above the SIRS we talked about earlier and other COVID support grant measures that we have. So I think it's important to come together. I think the next interesting feature I hope to see, I think the photographers, I remember very, very vividly bringing all our professional photographers association and Singapore members coming together in a focus group right here in, I'm in NTUC Center. So we had this gathering, and then I remember very vividly when we roll out the Personal Data Protection Act, many of them being affected. And we actually came together to feedback to the Personal Data Protection Commission. And immediately thereafter, there was some guiding instruction and directives. And there you go. Photographers can still continue their trade and deliver their services uninterrupted and not affecting. And I hope, in fact, another feedback which we did a couple of years back is looking at intellectual property rights of creative freelancers, including photographers. So I'm looking forward. I know we've been lobbying in this area, and I am expecting to see some changes to the Copyright Act next year.
It is important. Actually, I realized that during this COVID-19 situation, I also started to see a lot of people banding together. In fact, I do quite a bit of work with the arts industry, and I started seeing, for example, Facebook groups helping one another trying to fill in the SIRS form. There were also people where people started to talk about contracts together, right? I think the NUS schools has also come together to start the COVID website called COVID, COVID, where it brings together all the resources and information about COVID measures to people if they need that as well. So there are a lot of resources out there. I have also, I mean, the people at Law Society Pro Bono Services Office, the audience members, you will see in your chat group that actually there's a link for you to download the resources. They have helpfully put together all the resources that we have accumulated through the seminars as well as the documents that they have. You can click into that link. It allows you to download those resources. One thing that I would really advocate is this document called Advocates for the Arts. It is a book as well as a program that the Law Society Pro Bono Services Office run to help arts practitioners. So if you have queries about contract, there's actually a pro bono 20-minute legal session that you can apply for with Pro Bono Services Office to ask them questions. Even I think I saw some of Jukin's template clauses in the Arts Resource Hub as well. So there are a lot of this contractual documents as well as assistance available out there as well.
Yeah, in fact, Liansheng, if I may just take a minute to say that we are really on a treadmill. I mean, we're not going to like let our guard down and stop moving. I think particularly the NTUC and labor movement, we're trying to forge ahead to see the needs and the various challenges, particularly during this COVID-19 period. So actually, in fact, we are appealing to all of you out there who are watching this and who have access to the link. I think it's in the questions or chat or questions bar, which you are able to access to on the right or on the top right. If you can help me do the survey, it will be a great thing, because we just formed a PME task force called the Professionals Manager Executives, including looking after the rights and of course the protection of freelancers. So we are trying to get a lot of views from all of you. So if you can do me a favor, spend some time, about 5 minutes, you should be able to do the survey. If you can keep that link and of course do that survey, I'll be most thankful, because all this will be consolidated to some document which we will go public on, and of course provide recommendations to lobby for areas to look after your welfare interests.
I think we're nearing the end of the seminar, so I do some wrapping up. Of course, thank you, the two of you, for sharing such wonderful information that I think the freelancers will have found most useful to them. We cover really a wide range. I am also obliged to share certain things about Law Society Pro Bono Services Office. So while the members are actually filling up the link and the survey to give their views, I need to highlight that, like I mentioned, there was the Advocates for the Arts Legal Clinic. So if there are people who need, people out there, the freelancers who need legal advice on contract terms, employment, force majeure, which you have heard talked about in today's seminar, you can reach out to the Pro Bono Services Office. There's a 20-minute Pro Bono Legal Clinic service. It's pro bono, so you don't have to pay a fee. You can email them. There are also community legal clinics out there, the good work done by the people from the Pro Bono Services Office at various community offices. They run from Mondays to Thursdays. Then again, same thing, you just apply with them, you get a 20-minute session to speak with a practicing lawyer who will answer your queries pro bono as well, right? With that, I hope that you find our webinar today useful. Again, like Patrick said, we are seeking your feedback. We're hoping that you can help us answer certain things, give us some queries as well as feedback. We will reach out to you and really band together. Hopefully we can change things, improve things when we are banding together. Okay, there are resources for you to download. Remember to download it before you exit the seminar today, right? And really, we will appreciate your feedback for today's session. Any last words, Jukin or Patrick?
Yeah, I'll leave Jukin for the last word, but I would just want to say, hang in there. It's difficult times, definitely, but I think important for freelancers out there to come together, because I think unity is strength and unity is fortitude as well. So I hope freelancers out there, you're not alone. Yeah, NTUC and the labor movement, we have provided a series of resources, both in terms of looking after your welfare interests, and of course the various channels out there if you do eventually face or any challenges, or even if you are facing any disputes. I think help is out there. So make full use of the whole plethora of resources which Liansheng rightly put out. Law Society Pro Bono Services Office. In fact, today's primer is a partnership between the Law Society Pro Bono Services Office and NTUC, because I think we both mutually believe that we want to make a difference and of course help each and every one of you in your journey as workers or the working population, even as freelancers.
Well, I guess all I have to say is that really that the law is there to protect and to help, but more importantly is that we should actually think through before signing anything. We need to help ourselves by being aware of not only the resources that are available, but at least have some awareness of what are the laws and the regulations that you can protect you, as well as can trip you up as well if you're not careful. I think that there are a lot of courses that are being conducted from time to time by public services organizations on law, as well as on some of the practical tips on how to manage your business, your personal affairs. Do sign up for them, and it's never too late to learn, and it's always good to keep learning.
And with that, it only leaves me to thank you, Jukin and Patrick, for spending and sharing with us. And I also thank the audience members for tuning into this webinar. And everyone, I hope you have a great day ahead and enjoy your weekend.
Take care. Bye-bye. Thank you.